In cause number 2022 CR 1543, you're charged with assault on a peace officer or judge with a repeat offense enhancement allegation. Your range of punishment is anywhere from 5 to 99 years or life, and a possible fine up to $10,000. In cause number 2022 CR 1546, you're charged with possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams as a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison. Did you understand?
Welcome to the bench of justice.
All right, the court is calling 2022 CR 1546 and 2022 CR 1543, State of Texas versus Sean Foster. Could I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
Charles Bond.
And are you Mr. Foster?
Yes, ma'am.
I know you. You've been in court before. Okay,
Never misses a day.
never. Mr. Bond, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in each of these cases? And did you review those with your client?
Yes, we have and we did.
All right, and each of the cause numbers, just one moment. I'm so sorry. In each of the cause numbers, the court will find that the state is in compliance with discovery. And each of the cause numbers, Mr. Foster, I'm going to show you documents entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, sir.
All right, just one moment. Let me find the other indictments. This is the second indictment. Did you review that one with your attorney as well? Did you understand it?
Yes, sir.
Guys, please whisper. State and cause number 2022 CR 1543. Are you proceeding on the indictment as presented?
I believe so, Judge, if that's the assault on a police officer.
Yes.
Yes.
And you're proceeding with the repeater enhancement allegation? All right, and then in cause number 2022 CR 1546, are you proceeding on the indictment as presented?
No, Judge, we're only proceeding on count 1. We're going to waive count 2 as well as the repeater enhancement.
Any objection?
None.
All right, in each of the cause numbers, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them? And did you sign them in all the appropriate places?
Yes, sir.
In cause number 2022 CR 1543, you're charged with assault on a peace officer or judge with a repeat offense enhancement allegation. Your range of punishment is anywhere from 5 to 99 years or life, and a possible fine up to $10,000. In cause number 2022 CR 1546, you're charged with possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams as a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison. Did you understand?
Yes, sir.
In all of these cases, if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes, sir.
In each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, sir.
Did you understand by entering plea bargain agreements in these cases, you are giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into plea bargain agreements in these cases?
Yes, sir.
Counsel, has your client been able to provide you with any defenses to these offenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Foster, has anyone threatened you, coerced you, or placed you in fear to get you to enter pleas?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
In each of the cause numbers, the state is requesting that your sentence be assessed at 5 years in the prison. There are no applications. The cases will run concurrent. The state will take in consideration 2022 CR 1544 and 2022 CR 1545. Did you understand that to be the plea bargaining agreement in each of the cause numbers?
Yes, ma'am.
Defense
Yes,
is that the
Judge.
plea bargaining agreement state.
Yes, Judge.
The only addendum, Judge, would regard is what's written below. Yes,
Yes.
Judge. Correct.
Defense, I'm showing you the paragraph. I'm sorry, Mr. Foster, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor Levine, such motions.
No.
Next, I'm showing you outside the plea bargaining agreement. If you fail to appear for sentencing, your plea will stand. And if after reviewing the evidence, I find there is sufficient evidence to find you guilty and you don't appear for sentencing, then you'll be subject to the full range of punishment, which is up to life in prison and up to $10,000 fine. Do you understand?
Yes, ma'am.
Then in cause number 2022 CR 1546, how do you plead? Guilty, not guilty, or no contest? And in cause number 2022 CR 1543, how do you plead? Guilty, not guilty, or no contest? State any evidence to support the defendant's plea.
Yes, Judge. State offered State Exhibit 1 and all attachments in both cause numbers.
No objections.
All right, in each of the cause numbers, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, in each of the cause numbers, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Then in each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept in its evidence states exhibits 1 and attachments. And in cause number 2022 CR 1543, how do you plead to the enhancement, which reads, and it is further presented in and into said court that before the commission of the offense alleged above on the 24th day of July AD 2012, in cause number 2012 CR 5868W in Bear County, Texas, the defendant was convicted of the felony of possession of a controlled substance, penalty group 1 gram to 4 grams. Do you plead true or not true to that?
And Judge, we're printing that judgment for you right now.
All right, thank you. We're not on the record for when are we bringing this back?
We're gonna get a date after we finish.
All right, what date? How much time is your client asking for?
I'm asking till the end of August when I'm back in town.
Okay.
as you pointed out, he's always here. He is wearing a monitor, so we know where he is. He's not a flight risk.
All
He has
right.
no intention of stepping out on this good deal.
All right, Ms. Ferguson, can you give me an August date, please?
And Judge, it won't print the judgment. This is the court of martial. I don't know if I can give it once file 360 will load the judgment. I don't know if I can give that to you at that
But
time.
do you all have just the printout that shows what
His,
the charge is and
You,
that
will that be
that
okay?
it was sentenced? Yes, if the defense has no objection. Okay. All right, defense, the file 360 is not working.
That's fine.
And so they're going to give a printout if there's no objection from the defense that shows what he was convicted of and what the time was.
There's
Are
no
you-
objection.
Okay.
CR 5868.
I'm still not able to print out just the page on there showing the conviction and what time he got. All right, we're back on the record. And state, are you offering into evidence the B page that shows the conviction in cause number 2012 CR 5868W?
Yes, Judge.
Defense, do you have any objection?
None.
All right, then the court will find in cause number 2022 CR 1543, the court will find the defendant guilty. The court will find the enhancement paragraph true based upon his plea or true and based upon states exhibits 1 and attachments. In cause number 2022 CR 1546, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. And we will return for your sentencing on August 25th. You need to be here at 9 a.m. All right. Is there anything else from either side?
Just these, Judge.
Thank you.
Nothing else from the defense, Judge. Thank you.
All right. And state, then I will sign these dismissals once he is sentenced.
Okay, Judge.
So I don't. All right, just get your reset form and then you're excused.
Okay, thank you.
You're welcome.
In a tense courtroom moment, the case of Sean Foster unfolds with serious consequences hanging in the balance. Facing not one but 2 felony charges, Foster stands before the judge knowing his future is on the line. The first charge, assault on a peace officer with a repeat offender enhancement. The second, possession with intent to deliver a controlled substance, a crime that alone could cost him decades behind bars. The judge wastes no time carefully walking Foster through every document, every right, and every consequence. Has he reviewed the evidence? Yes. Does he understand the charges? Yes. Was he forced into this decision? No. One by one, Foster confirms it all, but with each yes, he also gives something up. His right to a jury trial, his right to confront witnesses, and even his right to remain silent. Then comes the deal. The state offers 5 years in prison with both cases running at the same time. Compared to the possibility of life behind bars, it's a lifeline, but still a heavy price. Foster accepts, but the past comes back to haunt him. A 2012 felony drug conviction is introduced, strengthening the case against him. When asked, Foster admits it's true. That single moment seals his fate even further. The judge finds him guilty on both counts. The evidence is clear. The plea is accepted. But sentencing is not immediate. Instead, the court sets a date, August 25th, 9 a.m., and then a final warning. If Foster fails to return, the deal disappears, and he could face the full punishment, up to life in prison. One decision, one deal, and no turning back.